Good afternoon, everybody. My name is Sharon Gauthier. I'm a registered nurse, and I own a company by the name of Patient Advocate for You. We're now with Win TV in Windsor, Connecticut, and we've started a new show called Senior Moments. And the reason why we've done this is because in my nursing practice now for 10 years, where we coordinate and do crisis intervention, mostly for the elderly population, we have found that there is a lot of information out there that we feel the general audience might benefit from in getting some education on. Today, my guest is a very good friend of mine and someone that I work with professionally, is Marialta Sparagna. Welcome, Marialta. How are you? So today we're going to talk a little bit about, what were we talking about today?
We're going to advanced directives.
Advanced directives. Advanced directives as far as what advanced directives mean and what they don't mean. And the reason we're doing this is that there is a lot of discussion about do not resuscitate, do not intubate, and what advanced directives are and what you need to have in place, whether you're young or old. And Marialta's practice is wrapped around estate planning, correct? Is that your expertise?
I'm an elder law lawyer, and I do some estate planning as well.
So let's talk a little bit about what advanced directives are. First of all, you want to make them in advance, correct, while you are alert and oriented and with the program.
Yes, one of the requirements is that you actually be competent and understand what it is you're signing. There are two types. One is a living will. And a living will is a document that you decide in advance what kind of treatment that you would like to have when you're in a specific condition. For example, a persistent vegetative state.
So you get hospitalized, you're maybe in a car accident, or you have a stroke, and you're in a position that you don't have a voice. So this document then helps guide the system, the healthcare system?
It does with respect to, if you've made some decisions in advance. I don't know if any of the audience remembers the Karen Shiva, Karen Ann
Correct,
Quinlan,
down
or
in
the
Florida
Terry
with the
Schiavo
feeding
case.
tube, correct.
Yes. So if you have an advanced directive, if you're in a permanent vegetative state and there's no meaningful hope of recovery, in a case like that, they will basically make sure if you're brain dead. But then the question is, do you want life-saving measures if you're in that state and don't think you're ever going to recover? For example, do you want a feeding tube? Right?
And that was the big discussion, I think, with the Karen Schiavo case down in Florida. And for those in the audience who aren't old enough to remember, that case was related around an event that happened with a pretty young woman who was in a coma for a number of years.
And the battle was between her husband and her parents.
Correct.
Her husband thought that she would not have wanted extraordinary measures, and her parents disagreed. And had she had a directive, done something
then
in
we
advance,
would have known what she wanted.
we would have known what she wanted.
And it really made national news at that time, and it was all related around a feeding tube, which would have sustained her life and would have been considered as extraordinary measure in his eyes.
In the
healthcare, parents' eyes.
In the parents' eyes, and I guess the the doctors are wondering for some. They want to know what you want, and if you don't have a voice, if you haven't put it in writing,
correct,
then they don't know. And the choice is really, there's a very nice form in Connecticut, and that you can fill it out, and you have to have it witnessed and notarized in order for it to be valid. But we let you make several choices. One is whether or not you would like a feeding tube, right? Whether or not you'd like CPR.
correct,
Whether or not you'd like an IV in terms of getting water.
right, fluids.
There's also the appointment of a healthcare representative. Now, the healthcare representative, which used to be called a healthcare agent, is someone who can make decisions for you if the doctor can't get informed consent. In other words, in order to get treated medically, the doctor has to believe that you understand the treatment he wants to give you, and that you understand the nature and consequences of the decisions and the risks involved. And if he doesn't think that you can give him informed consent, then they will look to someone to represent you. And if you have the opportunity to appoint that person in advance, and it's a healthcare representative. Now, they're the person who makes the decisions in the gray areas. For example, if you're not in a permanent vegetative state, if you're not in a coma, right? That's something that your living will would cover. But if you're, for example, if you're unconscious and there's maybe 2 or 3 forms of treatment that have, well, we can do A, B, or C. And the doctor's going to say, what do you think, A, B, or C? So that person would be making the choice of whether or not you got treatment A, B, or C.
So it doesn't take away your ability, as long as you're able to have a voice, to say what you want. It's really a document, a legal document, that will be there when you don't have that voice. So like you had said, if you're in a vegetative state, you have a stroke, and the physicians come to the family or whoever it is that may be appointed, that person that's appointed in that legal document would then make that decision. But it's based on what that person wants, correct?
Well, when I counsel people, I always say, you know, you really need to choose someone that you think is capable of making the decision that you would make for yourself.
Mm-hmm.
And it's also important to sit down and have a chat with that person and to talk about what kind of
you want.
interventions that you would like. Because I think for the person who's decided to take on this responsibility for you, they need to know what you would have wanted. For the, you know, so when they're making that decision, they can make it with confidence. And I don't think it's an emotionally easy thing to do for anybody, but in order for that person to do it and do it well, they need to know what you wanted. So, you know, not that anyone wants to talk about these, have these conversations, but it is appropriate. You know, a good way to start is, you know, look, I was just, you know, filling out, you know, some paperwork, and I was looking at something called an advance directive, and you know, one of the things I'm thinking of doing is having a healthcare representative. Would you do that for me? And if the person doesn't know, well, you have to educate them and say, well, it's a person that would make decisions for me if the doctor doesn't think I can make the decision for myself. And that's kind of a good way to kind of open it. And then you have to say, you know, these are the kinds of treatments I would want, or, you know, some people are like, you know what, I've lived a good life, and if something happens to me, I don't want any interventions.
Right.
Nothing extraordinary.
And extraordinary can be a lot of different things. So I think having that conversation, and for me, I think the good thing about starting this show, Senior Moments, and the reason I had picked that name is the fact that there is a huge senior population out there that's growing. And I know that I see from my practice, and I'm sure you see from your practice, oftentimes that families are in a crisis, and then that's when they come to us to try and make decisions, and there's really little that can be done at that point because the conversation never happened. So now with the holidays coming, one of the articles I wrote last year, which I reposted again in LinkedIn, talked about talking to families now that they're all together about this kind of thing. And the title of the article is "I'm Fine," because as you know and I know, what often happens is that families who often live out of state or sometimes out of the country or out of town will make serial phone calls to their family members, and mom and dad will always say they're fine. But when you're in their home with them during the holidays is really the time to not only try and start and have this conversation, but also look at whether or not they really are fine, and look at things like, you know, are they wearing the appropriate clothing for the weather? Are they taking their medications? Talk to them. Do they know what their medications are? Are they seeing their doctor on a regular basis? And from those conversations, they can kind of find out where their parents or loved ones are. And maybe bring up some of this conversation, although it's not the greatest dinner conversation they have. But I think with us both working in the system, we understand how important that is, because if you don't, then you're put in a position to have several family members now in a waiting room somewhere having a discussion about what mom or dad might want, and it may not necessarily be what they want. So the document that you're talking about, is that something that they can only get if they speak to their attorney, or is that something that they can download from the state of Connecticut, or is there another way for them to get it if they actually don't want to go to an attorney to get it done?
Yes, there are statutory forms, and they are online. And the attorney and I actually did bring a booklet
good.
with me, and it's called "Your Right to Make Healthcare Decisions: A Summary of Connecticut Law." And it was prepared by the Office of the Attorney General for the Department of Social Services. And Department of Health. So this is available, and it is available online. And if you want, at the end, we can probably put the citation for you up.
Oh, that would be great.
If someone wants to click on it and find it. And it is a wonderful book. It does go into detail about the specific provisions of a living will, and also what a healthcare agent is. It also talks a little bit about what happens if you're in a position and you haven't named someone in an advance directive to act for you, and that is conservatorships.
Correct.
So that if you haven't if you didn't do any kind of advance directive, and if you hadn't named a healthcare representative, then if is no one appointed for you, then a facility, in many cases, including a hospital, will petition the court for a conservator of person
To make those decisions.
to make those decisions for
So
you.
before we go to conservatorships, because you and I both actually share that role at times with my being conservator person and you being conservator of estate, I wanted to ask you whether or not this document is available, do you think, on every state? And does it matter what state you're in? Because if someone lives in Massachusetts, are they able to download something from the Connecticut website and utilize the same thing? Is it generally the same document, or does it make a difference from state to state?
States actually have their own.
They do.
They do have their own documents. And, the state you're in is probably the most important to do your advance directive. Chances are, if you need it, that's what's going to be used. Now, you can also, in this day and age, everything, you can upload, scan. I mean, we've actually faxed it to hospitals, out of town, if need be. So it's good to have it done in the state that you live in. Doesn't mean it's not transportable. One of the things that's important, is that you choose somebody, right, and that we know who it is. In some states, rather than deferring to your spouse, they might defer to your parents. Now, all states are different. They all have different laws, and that's one of the reasons we're 50 states. But it is something to note.
And having worked in the ER for years, I know long before this document became as prevalent as it is now, I know that for us in the emergency department and in the ICU, we normally always do go to families in order to come up with a consensus. The problem that exists with that, as you know, is that oftentimes there's a disagreement between the family as to what to do and what is the right thing to do. So again, encouraging everyone to try and get this done prior to that ever happening. But my other question to you is, do you think it's a good idea to have more than one person as your healthcare agent?
I think it's good to have one person be the spokesperson and make the actual decision maker. It's important to have backups. So if that person, for whatever reason, can't serve, or if it's a very tragic situation, maybe you're both in the same car accident, that you have a backup. I think if you have more than one person, that's where you run into difficulties. You may as well have none, because to settle it, you would end up in court if you can't come to some kind of consensus. So I always say, let's just have one decision maker. And I know that can be difficult for some parents. Mm-hmm. They want both their children or all their children to make that decision, but it doesn't mean that people can't get information. I mean, there are HIPAA releases for that, so that people can find out information. But I don't know, and you're in the medical community, so you can probably answer this for me, but isn't it easier if you have one person that is kind of the point person to deal with and be the decision maker?
Well, I think it is easier. I agree with that. And not that there isn't a discussion amongst the family, and hopefully when that decision has been made, that the family is also incorporated in that decision. So what you don't want is mom or dad to assign it to the oldest person in the family and do it in secret, and the rest of the family isn't aware of it. And I've been in situations like that. And then suddenly they're ambushed with, well, we never knew that mom had assigned you, and why didn't they assign me? And now the family dynamics become an issue in the hospital as far as decisions are concerned. But I agree, most of the instances that I've been in, either in my professional position in the hospital or in the position I'm in now with our company, is that when you do have one person, normally there's been a discussion with the whole family that has already been decided on, and the family's pretty good about honoring what that person wants. The difficulty has come in when there have been two people. And what happened to me last year is that I did actually get a call from a family member where their mom, who was extremely active, she was only 72 years old, she was in yoga class, so extremely active woman, had a massive stroke. She ended up at Hartford Hospital, and I have found that neurologists in particular are extremely honest with families in terms of prognosis, and she did have a very clear living will. But in the living will, the first person, who happened to be a nurse, was the youngest person in the family. There were 4 children. The second person, who was not a clinical person, was then the oldest person, who was the brother. When the neurologist had come to the family to ask them whether or not they should take her off of the ventilator and put a trach in, which is the breathing tube in your neck, which is usually the next step after someone's on a ventilator for a period of time. Did they want that, and a feeding tube, or did they want to just take her off the ventilator and see what happened? The first person on the living will had indicated that she wanted everything done. Regardless of what the living will stated, which the living will had stated from the mother that if she was in a vegetative state, if that she could not return back to what her prior level of function was, if she wasn't able to speak, if she wasn't able to walk, all those things that are kind of touched on, not necessarily in those terms in the will, it was pretty clear that she wouldn't want that done. And yet, the youngest of the group, who was the first person assigned to this role, said she wanted everything done. What ended up happening was, because she was on the document as the first person, they honored her decision. And the other children in the family came to me wondering what they could do, because they did take her off the ventilator. They did put a trach in where she could breathe through her neck. They did do a feeding tube. There was some immediate change, that was some improvement, but then she ended up in a vegetative state in a convalescent home. And the other children in the family were very upset over the fact that this was the way she was going to live. And she was relatively young. She was in her 70s, and wondered what they could do at that point. That's when I brought in another attorney group that I work with in Avon, and got a hold of them to have a conversation. And they were really stuck in this without maybe going to court and having a decision. And they now have a mom who is still living in a convalescent home in a vegetative state that she would never want to be in, with a feeding tube. The problem with that is that really to do anything else would be to go to court and have a discussion, and then look at the court deciding, probate court deciding, whether or not that person would be removed and the other families would be assigned. But then where does that leave them? That truly left them with making a decision for their mother to pass if they felt that would be the case, but taking away the feeding tube. And that, for almost everyone, is a very, very hard decision to make, because that's one of the natural things that people feel you do, is feed people, and they felt that they would be starving her to death. So that's an example, and the reason why I brought up about having one person versus two or three of the decision really wasn't made in her honor. My feeling was that Hartford Hospital, and not to really pick on them, but no matter what hospital they were in, really should have brought this to the ethics committee if there was a question about it or disagreement with the family that didn't honor her living will. But I also think there's a lot of confusion on the hospital side in terms of what a living will is and what a DNR is and what a DNI is. So I wanted to kind of circle around that by saying I absolutely agree with you. I think it should be one person, and not just one person, but once that person is assigned, that there's a discussion amongst all the family members, so they're really clear when that time comes that they'll honor what that person wants in a living will, which is when you're living and you're now making decisions based on what you really want. So now that we talked a little about that, I did want to talk about conservatorship. So you and I both have been put in a position where someone now is in that position that mom or dad or a sibling or a child even ends up in the hospital. Not so much for children, though. I think parents definitely have power over that without conservatorships when they're under 18, if I'm correct.
Yes.
But if they're over that age, or if it is an elderly parent and you've not done that, now you're forced with conservatorship, which kind of scares family members. So let's say someone's not done any of that, and now mom has a stroke and they want to make decisions and they're having a hard time doing it. Or the hospital comes back and says, you really can't make those decisions because you don't have that paperwork, so we're going to do everything because we're obligated. They now have to go to court. So what is that process then for the family to go to court? Because that's kind of scary to them when you say, oh, now you have to go to probate. It's not really a scary process, but it is definitely more complex than having a living will already, which would make more sense.
Well, probate courts have the authority by statute. So there are statutes which outline the procedures that someone has to follow. Now, it depends on who's going to petition the probate court. Right? Sometimes the institution actually petitions the probate court. If the person has no one, for example, or they can't find someone, for example, they will actually petition the probate court.
So the hospital
for
themselves
a
can
conservator.
petition the court?
Or, yes, because they need some guidance. They don't have the authority to make the decisions. And oftentimes, it's a conservative person, and that's the person who will make decisions about health care and where they live, and basically take care of all of their bodily needs, you know.
So
Conservative
there are
estate.
two kinds of conservatorships,
Right.
correct?
Conservative estate deals with the finances. So, and oftentimes, they'll ask for both to be appointed because all kinds of decisions need to be made and bills need to be paid. And if no one has that legal authority, for example, you can have a power of attorney which will appoint someone to deal with your finances, just like you can have an advance directive which will allow someone to make medical decisions if you can't make them. So a lot of times they'll ask for both. If the person is truly incapable of making any type of decision, someone needs the authority. So it may be a family member that volunteers to be the conservator. A judge will make that decision, however. So family members can volunteer. Family member can petition the court also to say we need a conservator. A lawyer is appointed for the person who's going to be conserved. That person is represented. So there are two types of conservatorships. There's basically voluntary or involuntary.
So voluntary would be someone who's cognizant enough but may feel they need some help and actually agrees to be conserved, correct?
Correct. And the judge will interview that person and make sure that they understand the rights that they're giving up. Now, a conservatorship can be tailored to fit the person's needs at that point. In other words, in Connecticut, we don't want people to lose any more of their autonomy than need be, so that many times a conservatorship is granted for some specific purposes, to make particular types of decisions. For example, maybe you can decide simple things, but you can't decide complicated, complex things. And it really depends. It's a case-by-case basis, and you're represented by counsel, and you may either go voluntarily or involuntarily to the judge. There is a hearing. Evidence is presented. A physician, if it's going to be involuntary, will generally see you and make some kind of medical determination of what do you have, right? What are your diagnoses? Is there a reason the physician thinks that you can't handle either your finances or your healthcare decisions? And there's a specific report that they will fill out, and that's presented to the court.
So online, under probate forms, I know in the state of Connecticut, there's actually a form for a physician to be able to fill out
Yep.
for someone to be involuntarily conserved, where there's a physician, and it has to be a face-to-face contact, I believe, within, do you know the period of time it is? Because I think they've shortened it.
I believe it's within 30 days.
So within 30
of the
days
hearing.
of the hearing, they need to be in front of a physician who can assess them as to whether or not they have the competency at some level to be able to make decisions on their own. And that physician can fill out that form for involuntary. So when the person, whoever it is, whether it's the entity, the hospital, or the family who goes to the court and says, I need to have conservatorship of my mom or dad, the court is then obligated, I believe, to assign to assign an attorney to represent that person, correct?
Absolutely. Because basically we're depriving you of your rights to make decisions.
Right.
Over your finances or over your medical care.
Right.
Those are pretty big rights to lose.
So that keeps anybody from really trying to take advantage of someone. So when that family member goes to court and says, I need to get conservatorship of whomever, the court then will assign an attorney to represent that person. And then that attorney is involved with having a conversation with the person, investigating whether or not there's a need, and really represent them very well, I have found, to be able to go back to court in that hearing and say to them, yes, that person does want to be conserved or not conserved, and they have an understanding, which I think is a great safety net. So in the last couple of minutes that we have for this, so once that that court has been petitioned, and all petition means is that you've asked them. Right?
Correct.
Right. They will then set up a hearing, and then I believe anybody that's related to that person or involved is invited to that hearing.
They're called
or can be.
Yes, they're called interested parties, and they get notice, right? They're entitled to notice. They can attend the hearing. And also, you're allowed to bring in witnesses in your favor or which support your position, whether you're the person asking to, who's asking for the court to conserve someone, or whether you're the person that says, look, I don't want the conservatorship. I think I can handle my own things. You're allowed to testify, and you're allowed to bring in witnesses to support your position. And after that, the judge will take in all the evidence, and then the judge makes a decision.
So the person themselves that's being conserved, if in fact they can go to the hearing, they do. If not, I've had probate court judges go to the place the person is at.
Yes.
So if they're in the hospital or they're certainly if they're in the ICU on, a ventilator, it's kind of a moot point and they wouldn't do that. But there's certainly a lot of investigation and interrogation and information that's gathered before the decision is made by the probate judge. Or you show up and that person shows up. And I've had cases where someone has voluntarily been conserved because they had a stroke and it affected their executive function. And so they were perfectly capable of being able to dress themselves and feed themselves and cook for themselves, but they couldn't take care of their bills, and they needed someone to be able to do that. So that was a good example of someone who had come to us, and then Mr. Bible, that you and I both know, actually became conservator of finances for this gentleman because of what was going on, and it was voluntary. So at that point, because it was voluntary, you didn't have to have an attorney that was set up by the court, correct? When it's a voluntary position, do they do that too?
Generally, they appoint an attorney if it's an involuntary conservatorship, unless the person themselves is actually going to the court and asking.
Correct.
The thing about a voluntary conservatorship is that it can be undone by the
By
person.
them.
Right. You write the court a letter.
And say, I don't want them anymore.
Correct. And within
Right.
30 days,
Right,
and the
and then it's done
conservatorship
with.
disappears as a matter of law.
We don't see that as often, I think, as we do involuntary. Normally, I think it's an involuntary conservatorship where someone is totally incapacitated for whatever reason, whether it's a dementia, an Alzheimer's, or a critical event that's happened, that someone's had to step forward to kind of take charge for them. But they're also accountable to the court, correct?
The conservator is, yes. So there are certain things that you have to go to court for. In other words, you can't, if you're a conservator of a person, you cannot just put someone in a nursing home permanently.
Right.
You need to file with the court and ask for permission to relocate the person. The same as if you're going to terminate a lease.
Right.
You can't
Sell their goods.
You can't sell their stuff.
Access
give
all their
gifts.
monies.
Yes, right.
So there is a big safety net, I think, that when there is a conservatorship, people understand that you're really not able to take advantage of this person because whatever you do, you have to present to the court. And I know on the conservatorship of person piece that we do, there is a yearly report that we have to submit. And that says, should it be continued, what we've done, how often we saw them, and the same thing rests for conservator of estate, correct?
You have to file an accounting, yes.
Every single year.
So you're accountable for what you spend. So it's
And-
very transparent.
Correct, which it should be. Well, thank you very much, Mary Alta. And your practice again is where?
Simsbury, Connecticut.
And it's you and your partner.
Andrea Melanson and I, it's Melanson and Sperania, and we're in Hot Meadow Street in Simsbury.
Thank you very much for coming. And again, this is Senior Moments. It's a new program talking about and educating people on what you need to know as you grow older in order to protect yourself. My name is Sharon Gauthier. I'm a registered nurse. I come from a company by the name of Patient Advocate for You, and we appreciate your listening.